they going to change the...
Would you mind changing the slides, please?
While we wait to change the slides, I've actually done something probably iconoclastic here. I'm going to abandon my slides altogether. Hearing Dag Johansson, that he is actually listening in and trying to learn how we think in order to challenge our cases. Perhaps the best way forward is for me to give an extemporaneous talk, an impromptu talk on the dominance rules on pricing and its practice. My colleagues, as Astrid rightly pointed out, would deal with the specifics. I would deal with it at the 30,000 foot or the 10,000 meter level, I should say. There is one slide, though, Waiting for Godot is the title here, that I do want to put up. Let me quickly. And it's that one. And it's this zigzagging that we see in commission practice and in advice that has caused terrible, terrible problems in Article 102. The legal community in Brussels, back in 2005 and then again in 2008, were waiting with bated breath on this guidance paper that the Commission was going to issue. It would finally get rid of this fiendishly difficult area of law and provide us clarity. It was very much like Saul of Tarsus, better known as St. Paul, on that Damascene road, waiting for the great revelation. We were all there. It was published, and was that revelation given to us? Unfortunately not. Instead, we were provided what is actually a sui generis document. It doesn't exist in any other area. It sets out the enforcement priorities of the Commission, the prosecutorial discretion of the Commission. It does not set out the law. And it focuses on exclusionary behaviour only. And exclusionary behaviour vis-à-vis the conduct of a dominant company, but not exploitative. So excessive pricing or price discrimination is absent from the paper. The initial paper, published in 2005, the discussion paper they called it, was initially actually well received and I believe encouraging. It suggested a careful review of the rules and the actual practice, and it showed some utility, both to external counsel and in-house lawyers. We should recall, and I'm not going to engage in commission bashing or anything like that. I'll do that later with Doug. The context of his publication should really be remembered here. Historically, the Commission had been criticised for being too formalistic with regards to the application of the competition rules, and it placed great emphasis at that time on the form of a given conduct rather than its effect. And to its credit, it sought to address those issues, beginning with Article 101 on anti-competitive agreements and the great revelation we heard earlier on January 2004, modernisation of competition law, very well received by both lawyers, economists, and indeed industry. And then it turned its attention to 102. Discussion paper in 2005, effects-based analysis, all good stuff there, the language we wanted to hear, the analysis we wanted to do. But the Commission was working under very, very strict constraints. Existing case law was hostile to this position. Current investigations, intel, for example, were influenced and could influence the paper. And indeed, it was subject to appeals. Microsoft was under appeal at the time. And all these factors had to be fed in to a guidance paper which could not be liberal enough to undermine those cases, but could not be form-based to actually not change their position. And the Commission did a remarkable job, I think, on the discussion paper. But when it published the 2008 guidance paper, it created significant uncertainty. and it created significant uncertainty for lawyers and for companies. With regard to pricing, as I mentioned earlier, it focused solely on exclusionary conduct. It stated that the Commission would only intervene when the pricing conduct hampered or threatened to hamper competition from an as efficient competitor. And we'll get back to what as efficient competitors are. Intuitively, it sounds like a strong and reasonable test. But in practice, it is very difficult to apply. And my economist colleagues here can tell me if I'm wrong on this. The benchmarks used to look and examine what an as efficient competitor is are costs. And two cost benchmarks were considered: average avoidable costs and the long-run average incremental costs. Again, sounds reasonable. In essence, where the price of a product does not cover the average avoidable cost of producing the goods, the dominant firm is sacrificing, and therefore there's potential abuse. The as efficient competitor cannot compete on an equal footing. Failure to recover long-run average incremental costs indicates the dominant firm is not recovering all of its fixed costs, creating the same issue. However, if an as efficient competitor can compete, the conduct is presumed to be lawful. This test is used throughout the dominance rules, but yet is one that is very difficult to apply in practice. And you'll hear later, for example, on margin squeeze. If we go back to first principles, what is a margin squeeze? Well, basically the test is, can the internal unit of a dominant company offer the services loaded with similar costs as a competitor and compete efficiently at profit or a reasonable profit? If the answer is no, then there's an abuse. I think it works well in theory, but in practice is proving difficult. Of course, the Commission makes clear that the data it will rely upon would be that of dominant undertaking. If you are the abused, it's difficult to get that data. If you're the abuser, it may be equally difficult to get that data, and the Commission will request it. As a proxy for that, they will use competitor information, but again, the same kinds of difficulties arise. So, do the guidelines offer sufficient guidance for pricing abuses? I would say no, and I would say it's created greater confusion in the legal community. I think that there are differing views between lawyers, and advising on the identical issues results in two diametrically opposed views. The risk-taking company may suggest, I will follow the guidelines. The risk-averse will just go back to old formalistic law. There's no chance of getting that wrong. In-house counsel and external counsel advising their clients, for example, on rebates, classic area. The ECJ prohibits loyalty rebates, so-called loyalty rebates, a term I've never liked because all rebates are loyalty-inducing, of course, while the guidance paper provides what I call a rule of reason approach based on a price-cost analysis. This analytical approach is not of great help to dominant firms who are seeking to self-assess their conduct and the legality of the conduct. It creates uncertainty and it chills competition. The legal certainty that the paper sought to achieve the same paper has actually created more uncertainty than in the past. And again, we see the same thing with retroactive rebates. EC examines the part of the market which is contestable. So the thought there is that the dominant firm has locked in certain part of the market that it's the go-to firm to provide that product or service. But there's a portion of the market that is contestable, and that is the market that is examined, and that is the market that is considered either that the dominant company has abused or not. However, what does that mean? How do you measure the contestable market? It's terribly, terribly difficult to do so. This, of course, and it's the theme of what I want to talk about, has created an atmosphere where it's very difficult to advise clients with any degree of certainty. And this zigzagging that we see, form-based, a hybrid, first case Intel. Intel, for example, should have been an effects-based analysis. The Commission, perhaps wanting to make it bulletproof, decided we're going to do a mix, form and effects-based analysis. And the reason why is, should it be appealed, they can point to the form-based analysis is in compliance with the law. Perhaps I'm being unfair, and it's a transitory period where the Commission will transition slowly over to an effects-based approach, and only an effects-based approach in line with its guidance. But as it stands now, in the transition, it's created huge uncertainty. Also, I believe of central importance is whether the Commission will follow its guidelines. Because as it currently stands now, the Commission is perfectly able to follow the case law, a strict form-based analysis and prosecution, and will succeed before any appeal in the General Court. Arguments of legitimate expectation, of course, can be raised in order to tackle that. I think perhaps they would succeed, but that may go towards the fine as opposed to the conduct. The laws on rebates, Hoffman-La Roche, Michelin 1, Michelin 2, BA Virgin, all these cases, classic cases, form-based rebate cases, create problems and issues for dominant companies in conducting their business. While I welcome the clarification given to the Commission, I think we do need a definitive statement of what it intends to do. As it currently stands, the law, unfortunately, is unclear. The prosecutorial priority of the Commission is clear, but it's not sure that they will follow it. It will depend on a case-by-case basis, and the effect of that will undoubtedly be to chill competition and make life difficult for in-house counsel. Thank you.